Good morning, ladies and gentlemen. We have a new sound system in the courtroom. So if you have trouble hearing or if it's much too loud or something, if you'll just let us know so that we can make sure that everyone can be heard and they can hear what's going on. This is our first argument to try out our new sound system. So thank you. Our first case for today is 2023-60601, West Texas Gulf Pipeline Company versus FERC. We'll hear first from Ms. Johnson.
Thank you, Your Honor. May it please the Court, Ashley Johnson for the petitioners. The Commission's decision to deny petitioners authority to charge market-based rates arbitrarily ignores an undisputed competitive reality. There is no consumer, no customer in the Tyler market that would be subject to any supra-competitive price if petitioners ever chose to charge one. The Commission not only acknowledged that reality, it relied on it in order to reject petitioners' claim that new entrant pipelines would enter the market in the event of a super-competitive price increase. Yet the Commission nonetheless concluded that the petitioners could exercise market power because the Commission's HHI calculation exceeded 2,500. The Commission's decision cannot stand. As the D.C. Circuit held in the Mobile Pipeline case, the Commission's calculation of a high HHI is no substitute for basic logic and commercial reality. The reality is that there is no basis to continue to force petitioners to charge regulated rates when there is no showing and no customer over whom they could ever exercise market power. The Commission's decision should be vacated with instructions to authorize the market-based rates.
So, Ms. Johnson, it seems to me from the briefing, which is very good, I must say, on all sides in this case, that the basic divergence, I think, is when you say there's only one customer in the market, and you say it's Delec. Delec's the only customer. Am I saying that right, Delec?
Yes.
Delec's the only customer because it's the only refinery, and they are insulated from market forces because of their agreement with Red River, is it? And then the Commission comes back and says, no, there are many customers because Tyler is an intermediate market, and there are companies that are passing through their product through the pipelines, and so those are the people who would be affected by super competitive rates. Is that the basic disagreement here? I mean, as I see it, it's very complicated. I'm trying to zero in on what's the basic disagreement, and if that's the case, what's your response to that?
I think that is the basic disagreement, if by Commission you mean Commission on Appeal. The Commission
yes.
Because the Commission in its decision below did not find that the pass-through shippers were the problem.
Okay.
In fact, it rejected this effective capacity method, which is pretty far in the weeds for how to calculate HHI, but it is based on, the Commission rejected the argument of the government that it ought to impose a different method in order to take account of pass-through shippers. It said, no, we always use the effective capacity method, which focuses only on who's in the market, and that's what we're going to do here. So the Commission calculated the HHI without regard to pass-through shippers. So there's nothing.
That's what you're saying. Not after the ALJ, the Commission didn't consider the intermediate market reality.
That's right. That's right.
Now that you're saying they're trying to bring that back in on appeal.
Right.
Okay.
So we say there's a Chenery problem there before you get to the question, the merits of the pass-through, which if you're.
No, that's okay. Exactly. I want to talk about the Chenery problem, and I want to say this is so interesting. When I was a young lawyer 100 years ago, and I used to want to be an antitrust lawyer, my job was to calculate the Herfindahl numbers, and I did them by hand, doing math, until I had a little computer program to do it. And so I never thought I would have a case that would deal with the HHI. So here we are today. My question is, if the Commission did not rely upon this theory in its decision, don't we have to remand it back? I'm not sure. I have a question about vacate and issue versus remand, but I'm not sure if we can even go forward if this is a new theory on appeal.
You certainly cannot affirm on the basis of a new theory on appeal. We do think that you could vacate and remand because this basic economic reality does not change. There's nothing the government can say to change it. And that's where the pass-through shipper argument, we think fails on the merits as well. And the reason for that is really kind of twofold. One is that by definition, these pass-through shippers have no need to use Tyler. And that is the reason that you normally would focus on the consumption in the market. Because if somebody is trying to ship oil from the Permian Basin, which the commission held was a competitive market, and they're trying to get it to the Gulf Coast, which the commission said is a competitive market, then if there is an inflated price to go through Tyler, then shippers will just choose some other path.
But wouldn't that be what we would remand for to be considered, whether or not there are enough routes and things? And it makes logical sense, but that wasn't the reason given. And so shouldn't they go through this and discuss that and do their job in that way? So especially when the data used is COVID data, and it just seems that it's crying out for a do-over, perhaps. And I'm not even judging the case.
Right. A few things, Your Honor. One is that this case has been ongoing for a very long time. I believe it was filed in 2018. So that's one problem with a do-over, is that it just stretches it out longer. The second thing that I would say is that there is a problem. It's not just an application problem of the fact that here we did put in evidence that there was not just evidence, but the commission found Permian Basin was a competitive market, Gulf Coast was a competitive market. But it's also the case that the commission recognized in its decision that it has applied the effective capacity method in every decision it has done since 1994. And the reason for that is the same thing as not looking at pass-through market. That is looking at the capacity actually consumed in the Tyler market and saying that is our only consideration. And so the commission has adopted that, recognizing that no method is perfect, but that is the best way to take account for the basic competitive realities of who actually needs oil in that market. And so for that reason, we think whether there is sufficient competition upstream and downstream, I think there clearly is, but we also don't think that it was proper for the commission, would be proper for the commission to even reach that question, because as a matter of their practice and treating the similar parties similarly, they have consistently focused on consumption in the market, and the consumption in the market is the Delaware refinery. And so they have to even look at this pass-through question is a departure from what the agency has consistently said is the proper way to go about it.
And on the point that they decided the case earlier, that the HHI numbers are too high, they would have needed to look at the pro-competitive and anti-competitive effects because of the range that the number, the 2,600 or whatever it is, and they would have needed to do that because this is not it doesn't give you enough information with the HHI numbers enough, but by themselves.
Right, the HHI numbers themselves, I mean, it's a helpful tool, and that's
right.
The reason that FERC uses it.
But they're not so dispositive. This is a on the edge number, perhaps on the edge.
Right.
So therefore it should have included pro-competitive and anti-competitive effect analysis, which was not done.
That is certainly right. We also think more fundamentally in Mobile Pipeline, the DC Circuit case, the commission had actually concluded that the applicant was a monopolist. It had a 100% market share, which would be an HHI of 10,000, so nowhere close to a close call. And then Judge Kavanaugh said, this doesn't make any sense. Like, I'm looking at this and I see your number is 10,000, but I can't make the logic of this make sense given that there is a lot of competition.
So even if it were dispositive, we should look at the pro-competitive and anti-competitive effects.
That's right.
But certainly where it's on the edge between them and you're trying to evaluate that, you need to do that.
That's right.
So what's the best case, though? I'm still hung up on remand or just straight up vacate and move on. So what can you help with the case law on that?
So the first thing that I would say is that the government hasn't actually contended it should not be vacated and remanded, and in fact, they dropped that argument entirely. So we think they have waived the request for a further reconsideration, probably because, as I said, I don't really think there's anything to reconsider given that the answer is clear under how the facts are set up. But also, this court has remanded in the BNSF Railway case versus Federal Railroad Admission. The court held that when there's no ambiguity as to what the agency must do on remanding without a specific instruction would be an idle and useless formality. We think that's where we are here. We are in a case where everybody agrees Delek is the only customer in Tyler that's going to use this oil. Everybody agrees that Delek has long-term contracts that mean it's not going to be subject to any increase in price. Everybody agrees that there's more capacity in the market than Delek needs, even if you ignore applicants' pipelines entirely. Given those facts, there's no ambiguity about what the commission should do when the case comes back to it, if the case were to come back to it. And that's why we don't think that it makes sense to reopen this multi-year proceeding to end up with the commission doing further analysis of the pass-through market question. There's a lot of reasons that you don't consider that. And one is, what is this inquiry going to look like? Are we going to have to look at every market from which someone could conceivably send oil through Tyler to get to somewhere else? Are we focused just on the markets where shippers are currently sending oil through Tyler? Because there's not really a reason to limit it in that way, at least a theoretical one.
Well, I mean, I think you could easily say, are there ones outside of the Tyler that take you from the Permian, that take you where you need to go? Are there 2 or 3 other options? That would be common sense way to analyze it.
Well, and the commission, the most obvious options have already been analyzed, because the commission did hold here that the Permian Basin was a competitive origin market, so that was not even set for hearing. And then after the hearing, it concluded that the Gulf Coast markets were competitive destination markets. So it has already concluded that those markets are competitive. And then the only question, I suppose, is could there be other markets from which people may also ship through Tyler? And then what other locations could they ship through? And both FERC has recognized, and then the DC Circuit recognized in Mobile Pipeline, that all shippers care about is the ultimate price. So no shipper is sitting there saying, I really want to make sure mine goes through Tyler. And given that we're talking about a pipeline system that goes from Permian Basin to the Gulf Coast, and there's already been a finding in this case that the Permian Basin is a competitive origin market and the Gulf Coast is a competitive destination market, sufficient questions have been resolved to show that there's no way for the applicants or the petitioners to exercise market power. And if we can't exercise market power, then we should be permitted to charge market-based rates and let the market set those rates rather than regulated rates.
So the Husky brief is just wrong?
Well, I don't know what they're wrong. I mean, they're wrong in their legal arguments for sure. Their argument, 2 things. One is these regulated rates are artificially government-suppressed rates. So it may well be that competitive rates are higher rates and that Husky would prefer to pay government-regulated suppressed rates than market rates. That is not an entitlement that they have, though, if we are not able to exercise market power. The second thing that I would say about Husky is they are just asserting, well, we would pay more, and they have not gone into, even in their brief, defending that they could not ship through another pathway. But the most important point, and Mobile Pipeline referenced this as well, is that saying that a price is lower than saying that your regulated rate is lower than you would have to pay in a market is not the same thing as saying that the petitioners can charge a super competitive price. It just means that we're entitled to charge the price that the market can bear, and if that price is somewhat higher than the regulated rate, then Husky is getting a windfall in the status quo, and the fact that they want to keep that windfall is understandable. They're not wrong to think it would be better to keep a windfall, but it doesn't mean that they're entitled to do it when we can't exercise market power.
I mean, forgive me, I don't understand this market this area very well, but if you're able to charge market rates Delec, I think, is not going to have to pay them, right? At
Right.
least for, I don't know, for the foreseeable future. So who's going to pay them?
Pass-through shippers. So pass-through shippers would pay the market rate, and then to the extent that petitioners ever attempted to oppose a super competitive rate, those pass-through shippers would just use the other competitive options available in the Permian Basin and available to ship to the Gulf Coast refineries, and they just change.
Okay.
But they pay market rates in other markets and can pay market rates in this market.
Okay.
Thank you. You
Thank
have
you.
time for rebuttal.
How's the new sound system? Can everyone hear us?
I think it looks great.
Can y'all hear well at your table? In the back of the room? Okay.
Clock, is the clock bigger?
I don't know.
It seems like the clock's bigger.
It does look bigger. Is it Ms. Gao?
Yes, Your Honor. May it please the court, Angela Gao for the commission. I want to start with the idea that petitioners presented that the commission somehow post hoc its consideration of other shippers. It did not. While the commission declined to adopt one of the alternative HHI methods, it nonetheless agreed with the ALJ that its existing approach, the effective capacity method, comes up short in an intermediate market like Tyler because it doesn't account for volumes from pass-through shippers. The commission in its orders repeatedly emphasized that the effective capacity method's shortcomings leads to HHI and market share that is artificially understated and too low, and that these metrics of petitioners could actually be significantly higher. And importantly, the commission relied in part on the fact that petitioners' metrics were artificially understated to further support its determination that this case did not present a close call on the metrics. So just because the commission didn't reach the issue of, how do we fix these shortcomings with the effective capacity method, what alternative method should we adopt, it doesn't negate the findings that it made with respect to the other shippers in the market in Tyler, the fact that Tyler is an intermediate market and that its existing HHI calculation has shortcomings that will understate artificially the metrics that it produces. I also want to talk about a little more about why the commission didn't adopt an alternative method. It declined because it was an issue that the commission didn't need to reach. The commission, when it acknowledged these shortcomings and found that the effective capacity method doesn't account for a large majority of these deliveries, and cited evidence that the 2870 HHI was too low and that these numbers should actually be significantly higher, it recognized these shortcomings, but it explained that it didn't need to reach this extra step of determining how to fix the shortcomings and come up with an alternative method because the outcome would be the same regardless. The existing numbers on the effective capacity method that don't account for pass-through shippers, the 2870 HHI and the 38% market share, the commission found was already too high to indicate that petitioners couldn't exercise market power. So there was no need to move on to this extra step of, how do we come up with an alternative method and how high should that HHI market share actually should be. It therefore declined to move on to set a new method of calculating HHI, in this case where doing so wouldn't affect the ultimate outcome.
So it sounds like the premise of this, what you're saying is the commission considered Delec was the only consumer on this analysis, right? We don't need to consider other potential consumers, pass-through shippers. We're only going to consider Delec?
It's
on this, and sort of on your premise, which we didn't have to go over here. We're just going to consider Delec, right?
alternative bases, yes. One of
Okay.
them was under the effective method capacity.
Okay, so just help me with the logic of that. Is
Sure.
it true that Delec is not subject to market pressures because of its agreements with Red River?
Under its existing agreements with Red River Pipeline and other existing pipelines in the market until I believe at least the next few years when those agreements expire, Delek would not have to pay petitioners market-based rates due to those agreements.
So given that's the premise, how is it, walk me through the logic of why West Texas still can exercise market power?
I think fundamentally, as our brief and the orders explain, market power isn't measured by looking at consumers in the market. It's measured by the market structure and the competitors in the market. That's why we rely on HHI and market share, because the individual circumstances of a uniquely situated consumer, that's not determinative to the ultimate market power analysis. We really have to look at, is there sufficient competition in this market that would prevent petitioners from exercising market power? And so in that analysis, that's why the Commission relies primarily on its metrics of HHI and market power instead of tracing each and individual consumer.
So now I understand why they're relying on Mobile Pipeline from the DC Circuit, because in that case, as they presented, the judges said, well, we get the HHI, but that doesn't make sense given the realities of the market. I think that's what they're saying. If Delek's the only competitor and they're insulated from market, then the HHI doesn't make sense, because against whom are they going to exercise their market?
I have two responses to that. The first being, mobile oil is really a dispute about what the proper origin market is. The court found the proper origin market was, I believe, the entire Western Canadian production fields for oil, whereas the market metrics that the Commission had calculated were under a much more narrow subset of the ultimate market. But second, even if we accept all that and we take the understanding that Mobile asks us to look at commercial realities, well, the commercial reality is that Delek is not the only customer in this market. And if we were to grant petitioners market-based rates, obviously Delek would be insulated for a few years based on its agreements, but ultimately it's the other shippers that would have to pay those rates. And
well, they just conceded that, right? That's why I asked, well, who's going to pay them? It's the other shippers.
Precisely, Your Honor.
But those aren't customers, those are competitors. And
no, they are customers.
Oh, no, I'm sorry, the people shipping, but they're not shipping through Tyler necessarily. So the issue is whether or not from the basin to the Gulf market, are there various ways in which they can ship? And if they are, then there cannot be market power here. There's no market power if there are alternatives readily available. And that analysis has to be done if you're going to rely on this theory of these other, they're not customers in the Tyler region, they're customers for pipeline capacity and so, and routes. And so you have to say, are there enough other routes available such that it won't be able to be a super competitive rate for routes? And that analysis has not been done, and it's been substituted that it was, well, the HHI is a rebuttable presumption when it's not supposed to be a rebuttable presumption anyway. So I just don't think this makes any sense. It's somewhat circular.
I'd like to address that in perhaps two parts. The first, I want to emphasize that the ultimate burden to demonstrate that petitioners can't exercise market power in Tyler, that's on petitioners. They bear the burden to make that showing. And
market power in Tyler.
In Tyler.
Well, there's only one thing that has to be shipped through Tyler, to Tyler, the Delek refinery, and we know that they don't exercise market power in Tyler.
As to that point, Your Honor, if petitioners want to rely on this theory, they bear the burden of showing that these other shippers have alternative routes that could go around Tyler. The issue is, as you've noted, they haven't done that. They haven't made that showing. They've just asserted it in their briefs below, and I apologize because they raised this for the first time in reply. We did not have a chance to cite the contrary evidence from the record that's included in the appendix, but this was hotly contested below. First of all, petitioner's brief notes that there are, I think, less than 30% of the shippers with pass-through volumes end up in these downstream markets, even that 30% was disputed. There were errors that commission staff's expert found with the volumes that petitioners had included in their calculations. That number should actually be significantly lower. And additionally, it also sort of assumes the conclusion because, again, petitioners, they bear the burden to demonstrate that they couldn't exercise market power, but their briefing below assumed that just because, you know, at most perhaps 30% of these shippers could go on to other markets downstream, that necessarily could discipline a super competitive price in Tyler. But that's an analysis that has to be made. There has to be some sort of analysis of, you know, what the critical loss is. How many consumers are you willing to lose in Tyler for that not to be outweighed by the benefit that you would have by charging super competitive prices? So because that showing was never made, that burden from petitioners is never met.
It seems like an important question. And as I understand what you're saying, and the other side is saying, that was not done at the commission level, right? Because the commission thought, as you said, we don't have to go there, right? We don't have to do that.
Yes.
What you're saying is that evidence is there, and if the commission had done that, you would still win. Is that what you're saying? In other words, they haven't made their case with respect to alternative shippers.
That's correct.
Okay. But it hasn't been done.
They haven't met
You're
their
saying,
burden.
I understand you say they didn't meet
Right.
their burden. The analysis hasn't been done at the commission level.
That's correct. That's correct.
Maybe did the ALJ do it?
No.
No. Okay.
The analysis hasn't been done at either level. And ultimately, Judge Duncan, as you mentioned, the Commission's primary rationale is under the effective capacity method, with all of its flaws, the metrics were still too high to indicate a lack of market power. And it's really this additional alternative basis that the Commission cited, even on top of that, these numbers we believe could be artificially understated because it doesn't even account for all these other shippers in the market. So,
what case says that this number is too high on its own without doing any analysis of pro-competitive and anti-competitive effects? That you can have a bald number and that this number is just so high that you don't have to do the roll up your sleeves and do the work. What case says that?
I apologize, I don't have it offhand, but we have cited Commission cases in our brief that indicate we only consider the pro-competitive factors in the event of a close call. And there is good reason for that. As Chief Elrod, you mentioned earlier, something like excess capacity ratio, that's not dispositive of the case. You can imagine, excess capacity ratio, it really depends on who holds that excess capacity and how many competitors are there in the market. If there are only a few competitors and those with the greatest market share are those that hold the excess capacity, they're not going to use it to discipline their own market power. It's, by an analogy, you can consider an area with a single grocery store. It's a very large grocery store. It's very well stocked. It has excess capacity, but because it's the only grocery store there, it can charge monopoly prices despite its excess capacity because it dominates the market. And so,
but the FERC is not there to try to prop up the Tyler market. They want competitive prices for shipping.
That's correct.
Throughout the region. And I mean, I would assume that that's the goal to the extent that the FERC has a role to play here.
That's correct.
So regardless of if they have all this excess capacity and they can't sell it, then because they're charging a super competitive price, then they're shooting themselves in their own foot. They'll have to eventually lower their price to use their excess capacity or else just be content with what they have. And so there's no, what's the issue, what's the interest of FERC there?
Well,
if they're not going to be able to charge the super competitive price, they're just going to have excess capacity if there are adequate alternative channels to Tyler. unless FERC's goal is actually to prop up Tyler itself.
It's not to prop up Tyler itself, but as Your Honor just mentioned, alternative channels, they haven't made that showing. If they'd made that showing, then perhaps, sure, the commission might have granted market power. But the issue is that they just haven't met their burden here. And I do want to emphasize that it's not as if petitioners are precluded from reapplying for market-based rates. They're free to do so. If they feel like they can fully explain their alternative shippers theory, then they're free to refile their application, and the commission can then consider that instead of having this debate on appeal, which, as you've noted, is inappropriate.
But the commission did not decide it on this basis. The commission just said the numbers themselves are enough. And the numbers are not, they're like within 200 points of other cases where it's not enough.
The numbers are higher than the other cases in which the commission has found a close call. But I'd also emphasize that it's not just numbers. The commission decides each case on a case-by-case basis based on those particular facts. And here, this is a market in which petitioners have only one other pipeline competitor and also local trucking. Those are their only competitors. They have an enormous market share of 38%, and it's a highly concentrated market. So the other cases in which perhaps the numbers were within 200 basis points while still being lower, I mean, they don't have the same factual circumstances that the commission was grappling with here. Also, you know, the thing is, with these secondary factors, the commission's primary determinants of market power is, as I've mentioned, HHI and market share. It's not that something like excess capacity could be used to supplant the commission's primary analysis. That's why it only considers those factors in a close call case, as you've mentioned, in an edge case, where something like excess capacity might be able to tip the scales in one way or another. But here, you know, being, I think, 370 points away from its usual threshold for competitiveness, the commission reasonably determined that's just not a close call, in addition to the fact that they believe the market was already understated due to the other shippers. I see that my time is up.
Thank you, Ms. Gao. We
Thank you.
appreciate your argument today.
Thank you very much.
We'll now hear from the intervener, Husky Marketing and Supply, Mr. Wagner.
Good morning. Good morning. Greg Wagner for Husky Intervener. I just want to touch on a couple points. First of all, we don't agree that this is a post hoc rationalization. FERC stated in the rehearing order, paragraph 48, that the analysis of market power required to support the authority for an oil pipeline to charge market-based rates involves an inquiry into whether there's an adequate competition of crude oil supply in the relevant market, not whether an existing consumer can avoid paying a monopolist rate under certain circumstances. That also ties into the burden of proof issue. They bore the burden of proof before FERC to establish that they could not exercise market power over their transportation customers. The Interstate Commerce Act requires that rates be just and reasonable for all transportation customers, not for refineries that happen to take ultimate delivery inside a market. Every single customer that they serve, all of them, are entitled to just and reasonable rates. They chose to focus exclusively on one single customer, the owner of a refinery, that was exempt from paying the market-based rates, and then they turn around and say that, therefore, we can charge everyone else market-based rates. Because these people will be exempt, you should just pay. And as far as the idea that you can just look downstream and say, well, you have many options to go this way and many options to go that way, our refineries are in Ohio. There's zero finding in this case. There's zero factual finding in this case that there is adequate competition to Ohio. We tried. We proposed additional destination markets centered around Toledo and Lima, Ohio, around the refineries that we own there. The petitioners successfully opposed that. They said that's irrelevant. Your interests don't matter. We've already exempted the one customer that matters, that takes the minority of deliveries inside the market. And ultimately, this is not a case where we should be talking about vacating or remanding for additional fact-finding. It's a burden of proof issue. It's their burden to prove we don't have the ability to exercise market power. It's their burden to prove that their customers would vote with their feet, vote with their pocketbooks in order to avoid Tyler. We can't just say, well, you're going somewhere else, you don't have to go through Tyler. We need to do an actual analysis. More specifically, they needed to do an actual analysis of that, and they failed to do so. Another thing I'd like to add is that FERC didn't agree, by the way that it calculated the HHI, that the only consumption that matters is inside Tyler. FERC made an assumption, I'm sorry, it expressed a preference for looking at consumption inside a market, but it also recognized that in the case of an intermediate market like this, the effective capacity yields an artificially low HHI. There's an excellent explanation of that in the Plains case, cited, I believe, in the Commission's brief, 188 FERC 61-103, paragraph 33. It's also discussed in the opinion here, paragraph 63, the rehearing opinion at paragraphs 117 and 175. We need to actually take a look, again, commercial realities. Let's look at who it is that has excess capacity, who it is that they're competing with. Who does West Texas Gulf compete with? If we take a look at the opinion at Appendix 6, we see that every single interstate pipeline in that market, they own it, but one. Every single one. So if someone has excess capacity, it's their excess capacity. And as far as, again, commercial realities, that's what monopolists do. They decrease output and increase price. So the fact that one giant dominant party and their market share, their actual unadjusted market share is in the record. I can't say it in open court, but it's shown in the record in the initial decision, I believe.
Why can't you say it in open court?
Because the other side designated as sealed before FERC, their actual capacity, and I'm sort of stuck with that.
Okay.
It's just happened to be under seal in the FERC record.
Okay.
One other thing I'd like to add is that right, so yeah, if we take a look at, your question about what case says 2,500 is a cutoff. Let's look at the opinion at paragraph 59, footnote 181. It cites opinion 558, the Gutman case, opinion 573, the Seaway case. The quote there is, commission precedent supports the granting of an application for market-based rate authority in each case where the HHI is 1,800 or less, in most cases where it's less than 2,500. Where it's over 2,500, they don't have a single case showing an over 2,500 HHI that is also acknowledged by the commission to be understated warrants a grant of market-based rate authority. So again, I would say,
how do you believe the fact that this is numbers during COVID affects this?
I think that that's when they filed the application. I think that you have 2019 data, and it's their position that that's a baseline, and that's a perfectly acceptable position to take, but you have to prove it up.
No, but what I'm asking is, what impact do you think it makes on the HHI? Do
None.
you think that it makes?
I think it has none. I think it's a quibble about whether you should increase the local production, which is a minor competitor compared to the dominance of the energy transfer owned pipelines. So it's 48,000, 52,000 or something like that. That doesn't matter.
You don't think it's going to impact it at all?
No, I think it would be wrong to adjust it and to look at older data on the assumption that that's the normal baseline.
Is there no newer data at this point?
Not in this record.
It's been going on so long.
Not in this record for when the administrative record closed, which brings me back around again to if they'd like to file again, they're welcome to file again. It's not a matter, when FERC said file again, it wasn't file again because we got it wrong, so try again. What they said was, this record doesn't cut it. If you have a different record, if you have a post-COVID record that does something, file again. But again, it's their burden. There's no need for a remand because they failed to show that their customers would be able to avoid an exercise of market power. The customers that matter, which are the ones that are going to pay the rates. Thank you.
Thank you, Your Honor.
Why is that under seal?
Why is it under seal? I know some of the specific numbers were under seal in the commission proceeding. It's not relevant to this appeal because he was planning, I think, to give a number that's not based on the effective capacity method. So they've just stayed sealed because they were not a part of anything relevant to this appeal. So there were just 3 quick points that I wanted to make. One, I wanted to make sure, Judge Duncan, that you understood our position in terms of, you referenced us agreeing that other shippers would pay the market price. We agreed that other shippers would pay the market price. Other shippers would not pay a super competitive price, because if there were a super competitive price, they would have sufficient other options to swap elsewhere. And that brings me to number 2. I want to point the court to what the commission held. It's in paragraphs 59 and 60 of the commission's order, which is in the appendix, docket 122. I think the government is over-reading what the commission said. The commission said, since order number 572, the effective capacity method has been used in all commission orders addressing contested market-based rate applications set for hearing. And then in paragraph 60, we recognize trial staff's concerns regarding the use of the effective capacity method in this case, but nonetheless, for the reasons discussed below, we find it is appropriate here to use the effective capacity method. It is true that they acknowledge that other methods might give a higher number, but they were bound by their precedent to use the effective capacity method because that is what the commission consistently has said is the best measure of market concentration. So the fact that the commission gave some language about, well, you know, maybe that does understate it, does not change the fact that focusing on consumption in the market, which is what the effective capacity method does, is the way the commission has done these things for at least 30 years. And that is why it would be a departure for the commission to analyze the pass-through shippers, because normally they focus on consumption in the market, and that is what other petitioners, applicants have had to show. My third point.
What about the argument that you bore the burden and you failed to introduce the economic studies that you needed to introduce to show that there are all these alternatives when you had the opportunity?
So that was my third point. I would point the court to the appendix to, it's tab 288, pages 66 to 72. It's page 552 of the appendix. This is evidence that we put in before the commission. So there is absolutely no case to be made that we did not argue this to the commission or that we did not put this evidence before the commission. That is false. The commission did not consider the pass-through shippers or reach any conclusion. But what we argued at length.
Did you just argue, or did you put some data, some economists saying this and explaining it and all of that?
So we pointed the court to the previous findings on this specific. So we said, you know, it starts in Permian Basin or Fort Worth. In your hearing orders, you previously concluded that the Permian Basin and Fort Worth origin markets were competitive. And then we cited the discussion in those hearing orders that had previously made that determination. And then we said the commission has found the Haynesville origin market, which was...
You're telling me what you said. I'm asking you if you included any studies or any evidence to back you up.
So on most of
their own, you're arguing back to them what they've said in the past. But that's different than, did you have a study, an economist model this or something and provide it?
2 things, Your Honor. It wasn't really what they said in the past. Some was what they said in this case, on the record in this case. But second, yes, we did also put in data about the amount of crude oil shipments that were ultimately delivered to the Gulf Coast, which was competitive. We pointed to the testimony of Dr. Gill, who was the staff's witness, and then we pointed to the evidence that the government referenced of the percent of...
But you didn't put in your own studies or anything. Did you do your own studies?
Well, we put in data about where the oil was going, if that's what you mean. We did not... We had put in data previously about why the Gulf Coast markets were competitive. Yes, that data was in. It just had already been found. So at this point, the court had, or the commission had already reached that conclusion. So we did not reintroduce it when it had already reached that conclusion. But there had been data before the commission, yes.
What about the point that instead of arguing about, well, the COVID numbers distort, you can just do you can apply again using the new numbers, the modern numbers, which may be good for you.
The problem with that, Your Honor, I would point you again to the BNSF railway case, which just says it's not a defense to a current arbitrary decision for them to say, well, you can always apply again and we'll do it better this time.
Well, no, but if they did not do it better, they used the data that was commensurate with the time period at which you applied before.
Right, they use data.
So that would not be necessarily criticism of them.
They used unrepresentative data. That is a criticism of them. But yes, we also think that the capacity in 2019 continues to be the relevant amount of local production that could ramp up in the event of a super competitive price. And so our view is that the 2019 data, because what they're using that data for is to calculate how much local production there is. Because there's so much excess capacity in this market, not all local production that's possible is currently being used. So we don't think that the current numbers, if they were in the record, there'd be any reason to override the 2019 capacity of the market, because if there were a super competitive price, presumably local production would expand to that level regardless of what it is now. But I think more importantly, we just don't believe that we should have to start this process over, given how long this case has been going and the fact that there simply is not a possibility for us to exercise market power here. And so we should be granted the right to charge market-based rates rather than just further proceedings.
Thank you. We have your argument. We
Thank you.
appreciate all the arguments in this case.